Won't matter if you have transportation, you'll be in custody to get the help that you need. Either you take advantage of that or you don't. So you're going to get all the tools for both mental health issues, drug use issues, self-medicating, all of that. And when you get out of SafeP, you'll be on the high medium caseload in order to do whatever it is to follow up with spinal tap, follow up with drug treatment. And at that point, if you don't do it, there's no arguments that your attorney can make that would convince me that you should get another chance. This is your chance. Do you understand? Yes, and this is cause number 24, DCCR 0766. Ms. Lewis was granted probation for aggravated assault with a deadly weapon back in September of 2024. This is a motion to revoke. She pled true to counts 1, 2, 3, and 4. I've received an updated pre-sentence report. Have you both had an opportunity to review that report?
We have, Your Honor. Stay asked you.
And this was unagreed, correct?
Correct. Yes, Your Honor.
All right. Mr. Parker, you may proceed.
Your Honor, just first like to point out she has no new cases. Part of her issue, I mean, she's not reported. She's claimed some mental issues, which although the probation department didn't have knowledge of, I think they've confirmed that by talking to the infirmary, the jail. And I believe she did have issues. She was in a wreck, and I can tell you, she's acknowledged to me that she's told me the right things, which was promising, that she didn't go to probation because she was in a wreck and she was uncomfortable and it's hard to her. She also acknowledges, I should have gone. I should have had better contact with my probation officer and done what I'm supposed to do. She's very convincing to me that if she's given the opportunity, she's taking the medications that she needs to take, and that she will be able to complete her probation. I'm asking the court to put her on the high medium caseload and see if she does what she says she can do. If she's on her medication, and we can see if she actually will report. I mean, it won't take long to see if she reports and she starts doing a community service. They're administrative violations pretty much, and I'm asking the court to give her another chance. And do you want to address the court? Hold on. And she'd like to address the court, Judge.
Go ahead.
I would like for another chance, and I promise that I'll make sure that I do all my things that I'm supposed to do for my probation.
Explain to her what you told me about why you didn't do what you're supposed to do the first time.
I got in a car accident, but like I say, I'm not using it as an excuse. But I was out on transportation and stuff like that, and I couldn't really make it to where I was supposed to make it. And I've been taking my medicine. I've been doing everything that I'm supposed to, and I promise that I'll continue doing everything that I'm supposed to do to complete my probation.
And you told me what should you have done when you weren't going? You should have done what?
I should have reported.
And you should have communicated with them.
I should have communicated, especially with my probation officer.
Mr. Coleman?
I don't have much to offer, Judge. Saying things and making representations, they're easy to do and easy to say, but it's the deeds, the actions of the defendant that matter. And Judge, she's essentially done nothing on probation. If it's a mental health issue, she's got to take the first step, Judge. She has failed to enroll in Spindle Top to get those mental health, mental health issues, if any, addressed. You can't do this probation for her, Judge. And the definition of insanity is doing the same thing over and over and expecting a different result. Putting her back on probation, given the fact that she's just utterly failed, would be, in my opinion, doing insanity, doing the same thing, expecting a different result. She's just not going to. Her past behavior has indicated she's just not going to be successful at probation.
Your Honor, I don't think that's fair representation, because obviously the probation department didn't know she had a mental health issue. They acknowledged that, and when they do know that, they take steps to help these people that have problems. And she did take steps to get on medication, and she has improved by being on medication. I think with the assistance and the knowledge that the probation department has, that she has a mental health issue, and she actually is taking medication for these problems, it may help her. She may have a better chance.
So I'm looking back at the original pre-sentence report from 2024. Mm-hmm. And so it was noted in that pre-sentence report in 2024 that she had an appointment with Spindletop for a specific day that she failed to show for during the pre-sentence report, that time period. So it's not a surprise to anyone that there was some issues back then that weren't followed through with to go to Spindletop. That was ordered at it was in the order back then for her to be assessed for services at Spindletop, which never happened. So here's the thing. Here's where I am. I don't disagree that, I mean, Miss Lewis has really no criminal history. This is the only case. There's clearly some mental health issues as well as drug issues. But I'm not going to just say, okay, go out and do Spindletop, because we've already said that a couple of times. So what I am going to do, and this is your opportunity to take advantage of this, Ms. Lewis, is I'm going to find that you entered your pleas of true to counts 1 through 4 freely and voluntarily. I'm going to find those counts true. I'm going to find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that. I'm going to continue you on probation, but I'm going to order that you enter and successfully complete the special needs safety program. That will address all of these problems. If you say you want and need help, so this was not an agreement. You do have some rights to appeal. I'm handing you that written certification. I hope you take advantage of this and get everything you need because you'll be given that opportunity, okay?
Yes, ma'am.
All right, good luck to you.
Thanks.
Thanks, Judge.
Good morning, you're Leroy Harris.
Yes, ma'am.
And this is cause numbers 24 DCCR 0404. Mr. Harris is charged with murder, and 19 31482 charged with possession of a controlled substance. What is the announcement?
We have a tentative plea agreement, but it needs to go through the channels before, so we just need whatever the state needs.
And Judge, the court has been patient with us with regard to his Harris County case. That was obviously resolved. Not quite what we had anticipated that resolution would be with respect to also taking care of this case. But we did bring him back. Those cases are pending. I extended a somewhat of an offer to Mr. Burbank with the understanding I needed to know some specific information before I took it above my head, which he's now informed me that would be an equitable resolution. So I just need to get a little bit of approval for that, and hopefully we can wrap it up just at the next plea setting. I mean, maybe not a definite to plea, but we're close.
Okay, let's reset it 2 weeks. All right, we'll reset your case 2 weeks. Kavon Saunier.
I made a mistake on this. They've indicted him as a first. I think I put it out as a second.
Okay.
All
All right, Mr. Nicholas.
Good morning. What we say? The count on the rejection, the second, is having divided. I don't know. Right.
No, go back.
Good morning. Are you Kavon Saunier?
Yes, ma'am.
And Mr. Saunier, you're charged in cause number 25 DCCR 1530 with a first degree felony offense of aggravated assault with a family member. And that's from September 28th of 2025. And what that means is that if you go to trial and you're found guilty, the range of punishment would be a minimum 5 years up to 99 years or life in prison. Do you understand? And I have here on the tablet a plea bargain rejection that you've signed with Mr. Burbank. This shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty or a 20-year term in prison. You have every right to reject that offer and have your case set for trial. I just want to make sure you understand what the possible consequences are if you go to trial and what your options are if you wanted to enter a plea of guilty. And do you understand all of that? And do you want to reject that offer and have your case set for trial? And I did make the adjustment on the plea bargain rejection from a second to a first that he's been admonished. Is there any reason to believe that that offer would change?
No, Your Honor. I know there's some questions with the complainant that he's aware of because he talks to her on the phone all the time, but the state's offer's not changing.
Okay. So you're talking to her on the phone from jail? Okay, so I'm ordering today that you are not allowed to have any contact or communication at all with Delaney. Is it Sance? Okay, you cannot talk to her. You can't call her. You can't send her letters. You can't send messages through anyone else, period. Do you understand? If you're caught doing that, things are just going to get worse, okay? All that information will be information that a jury can hear or I can hear. Mr. Nichols will hear it. So I'm ordering you now that you are not allowed to do that. If we catch you doing that at the jail, I can order that you have no telephone and none of those things. Do you understand? Okay. All right. Go back with the bailiff. Pay set for trial.
Thank you, Your Honor.
Thank you, Mr. Burbank.
That's it. I think we had a Robert Griffin. He was placed in federal custody this past week. He may be off without.
Yeah.
I have excuse.
Yes, sir.
Until 1 o'clock.
Yes, sir.
Is it 1 o'clock? One for
One. Mr. Eckhart, you have Timothy Bessard.
I do, yes.
Morning.
Morning, Judge. You're not gonna say good morning?
I already did.
He's already been up here.
My first one's good for me.
He's always got to show off.
Here, calling for you.
Very far.
Good morning. Are you Timothy Bessard?
Yes, ma'am.
And this is cause number 26 DCCR 0276. Mr. Bessard is charged with aggravated assault with a deadly weapon. And 26 DCCR 0600 charged with murder. And what is the announcement?
Judge, I talked to the parent this morning and we have discovery, we have media. However, we are still waiting on a number of different lab reports. And for sure the murder, and I think maybe also the aggravated assault.
Okay.
Specifically DNA.
Okay.
And so I think we're kind of at a spot where we need to kind of stall a little bit until we get those reports in and get the files in.
That's correct, Judge. We're working on some things.
Okay. Any idea of?
I don't know, but I'll look into it and see if they can step it up or anything.
Okay. If you'll, obviously since he's in custody, if you'll take a look at that, we'll reset it so that you guys can work on getting that DNA, those results back, and then we'll see where we are. We'll do about 45 days. But if you'll check on it, see if they can kind of bump it up if possible, that'd be great.
I will, Your Honor.
Thank you. All right. You
Yeah,
go back to
listen,
bailiff.
thank you, ma'am.
See, Mr. Eckhart, you have Robert Trahan, 3 cases.
Great.
Let's get, well, he's got 2. Dalton Batiste also, or just switch on whichever.
Judge, I found another case in that case, if I'm not mistaken. I don't know if the court is inclined to admonish the defendant on it. I think there was an accumulation. Yes.
On Trahan?
Yes, in the enhancement.
Yeah, I'll do Trahan real quick, and then Batiste as soon as that one's done. All right, sir, you Robert Trahan?
Yes, ma'am.
And Mr. Trahan's cases are set for trial to begin with jury selection next Monday. There's 3 cases. We've got 25 DCCR 1094 charged with unauthorized use of a vehicle, 25 DCCR 1317 possession of a controlled substance, and 25 DCCR 1536 charged with evading arrest or detention with the use of a vehicle. And what is everyone's announcement?
You first.
State's ready.
We're ready. Judge, I do have, I was special set in orange on a bond case. So I don't know how you want to handle that, but I was special set before this case was set.
Is there a protection order or it was just a setting? But they're on bond?
Yes,
In whose court?
Townsend.
Talk to them and we'll go from there.
And I
But
have a
if,
pretrial in that court tomorrow. So if whatever happens here, if I know before tomorrow. then I
yeah,
should-
you'll know the number today of your case. And so it looks like the state, well, Mr. Coleman, which case would the state elect to proceed on?
The evading judge.
All right, so 1536 would be the numbered case. And it looks like the state has filed a notice of intent to introduce a extraneous? Is that just for punishment or is it any enhancement?
It's for punishment, Judge. The indictment has already enhanced this case to 25 to 99, if I'm not mistaken.
That's correct.
And the
And
state.
it looks like the previous plea bargain rejection, when we were here in March, was for 7-year term. Is that correct?
Yes, Judge.
And so, Mr. Trahan, there's only a couple of cases left set for trial, so it's very likely that yours will be close to the top of the list to go to trial next week. I want to make sure that's what you want to do, understanding that if you're found guilty and if those prior convictions are true, that you would be looking at a minimum of 25 years in prison up to 99 years or life.
Yes, ma'am.
Okay. And it looks like the state has also filed a motion to accumulate, which means you've got 3 cases. They're all from different offense dates. And so if you're found guilty on one, then we could go to trial on the next one. If you're found guilty on that one, the state could ask that any sentence you get, if you're found guilty, be stacked on top of each other in all of these cases. Do you understand that as well?
Yes, ma'am.
Yes,
And not to get into the facts of the case, have no doubt Mr. Hickard has gone over the video with this defendant, but Judge, it's captured on video.
And have you looked at the video?
Yeah, it's a misunderstanding.
Okay, I just want to make sure you've seen it, y'all discussed it, and so we will number the case. I'll number it as soon as docket's over, and we'll let you know so you know what to do about next week as well.
Thank you, Judge.
All right, thank you. You can go back with the bailiff. Mr. Gertz on Dalton Batiste, Jacoby and Dorsey.
Judge, I just got the media on that today. So got the paper discoveries, need to go over the media. and
Okay,
the
wait, hold on, they're getting them.
There's no objection to a reset.
We should be ready to. I'm very blue on that camera.
Yeah, it turns you guys all into Smurfs. It's blue hair, blue jacket. It's like even your gray jackets, y'all both look blue.
My gray hair.
Yeah. We noticed it on Mr. Nichols first. His hair was very blue. We made some adjustments and it looked better, but it's kind of back to
I
the,
need a gaffer.
it's because we have these gray made in the USA spotlight cameras that they made us.
I'll go with Gaffer later on.
All right, so are you Jacoby and Dorsey? And this is cause number 25 DCCR 1896. Mr. Dorsey is charged with manslaughter. It's my understanding that Mr. Radford was able to receive this morning the media and any videos and things like that. And so what I'm going to do is reset the case for about 30 days. Mr. Radford will be out there to go over all of that with you, and then we'll get an announcement at the next court date now that he has everything, okay? All right, you can go back with the bailiff. Lively Stratton. Lively Stratton. Any correct. Correct. Good morning, sir. You're live in Stratton.
Yes, ma'am.
And this is 19-33601. Mr. Stratton is charged with capital murder. And what's the announcement?
Judge, we have gotten, I think, all of the media, but we're having a wrinkle with one of the police reports that's rather lengthy that Ms. Molfino is trying to figure out why it's not transferring over from the old program.
Okay. Other than that, though, everything has
Other
been.
than that, I'm missing about 20 or 30 pages of police report. Other than that, I think we're good.
And what we're doing, Judge, is somewhat equivalent to kind of a reverse manual bait stamp, if that makes any sense. With it converting from workflow to Odyssey, there was all kind of glitches, including the media. We have recreated that from originals at the police department. But maybe that some of it is merged into one another, but myself and an intern are going through it this time and just documenting every single page number so I can get that to Mr. Radford and he can tell me which 20 is missing, because just I'm missing 20 out of the 2 red wells I had. It was difficult, and I wanted to, of course, have everything, but I think we've probably exhausted all of our discussions regarding the judge and are headed to the trial docket.
So is there any reason to believe that those pages out of that police report would change the position?
I don't know, but I doubt it, but I don't know.
So here's what I want to do. I'm going to give one more reset for an announcement.
Okay.
If the case is going to trial, I want to try it before the end of the year. So we're getting already halfway through the year. So we need to start looking at some dates and what's available if possible before the end of
I'd
the
like
year.
to get a special setting judge. I have some out-of-state witnesses that.
Yeah, no, it's going to definitely be, I think because it's the nature of it and we'll definitely make sure that when it's set, it will be the case to go. We'll do a
Yeah.
protection order if you need it and
Yeah.
things like that. So we'll make sure everybody's available. If you have any other cases that are set that you know are going, that are specially set, kind of maybe start an email with me, you guys, and we can start coming up with a date. Obviously, if something happens before then and it's taken care of, that's one thing. But if we want to start looking for a date, let's go ahead and start looking for that
I
now.
guess we can, after we get the next reset, we can have a pretrial conference in chambers and get some dates.
Yeah, I mean, just start an email
Okay.
and we'll start it that way. And
Because I have so many family members, I will reach out to them now and kind of take a look. If, obviously with the age of it and the witnesses, et cetera, it's a lot of moving parts.
it
So
is a
I'll try
lot.
to
So
get-
that's why we need to get it set so that everybody can get everybody here and subpoenaed, and we don't, we can't. It's going to be difficult for everybody to be completely available, but if they know ahead of time and they're under subpoena, then they won't have a choice.
Do
So
have
I'd rather do it that
I
way.
do have a trip planned out of the country for Thanksgiving.
You'll just make sure you have that
I'll send that to him.
vacation letter
I
in.
will off of it.
Okay. All right. So let's just do 30 days. That way you guys can please get the police report. If that changes anything, we'll know then. Otherwise, between now and then, let's start looking at other dates, but we'll have one more announcement
Yes, ma'am.
before trial.
May I be
Okay.
excused?
Yes. Mr. Parker, you have Darius Rigsby. Morning.
Morning.
That's an aggressive.
Well, it wasn't meant to be. I did that to Judge Davis one time. I went back and clapped my folder. He was back there and I didn't know it, and it bounced. He thought this was a heart attack.
Good morning. Are you Darius Rigsby?
Yes, ma'am.
And we are client waive the formal reading of the indictment.
You know, Your Honor.
Mr. Rigsby, in cause number 25 DCCR 1089, you're charged with a state jail felony offense of unauthorized use of a vehicle from May 18th of 2025. And how do you plead to that charge?
Yes.
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1,
No objection.
it's admitted. Is there any evidence that Mr. Rigsby is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of unauthorized use of a vehicle. Sentence you in accordance with your agreement to a term of 12 months in the Jefferson County Jail under Section 1244 of the Penal Code. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, so you did waive your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with me. All right, good luck to you, sir. Can you go back with the bailiff? Andrew Howard. Andrew Howard.
Leave no one to listen to the other judge.
Good morning. Are you Andrew Howard?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
Well, Your Honor.
Mr. Howard, in cause number 25 DCCR 0742, you're charged with a state jail felony offense of fraudulent use or possession of identifying information from April 18th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Parker?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
Objection.
It's admitted. Is there any evidence that Mr. Howard's not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of the state jail felony offense of fraudulent use or possession of identifying information. Sentence you in accordance with your agreement to a term of 18 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I will sign a dismissal as part of this agreement in clause number 25 DCCR 0741, and this will also run concurrently with your federal case. Now, as long as
They've already been sentenced over there, and I think we're good with that.
okay, I just
I've
want to make
explained
sure.
to him that.
Well, I'm going to make sure I explain it too. The federal system does whatever they want. So I'm going to say that this runs concurrently with their case, but that's completely up to them. Okay, so it sounds like it's going to be no problem, but if it's for some reason the federal system says it's not going to run concurrently and you have to do one before the other, there is absolutely nothing I can do about that other than what I say today and what the intention is. Okay.
Yes, ma'am.
So that case is 1:25 CR 56. And as far as I'm concerned, it will run at the same time. Okay. I'm handing you the trial court certification. That shows that this was an agreement that I followed. And so you've waived your right to appeal. I also handed you a written admonishment.
Courtrooms aren't just about punishment. They're about choices, accountability, and second chances. Which ruling surprised you the most? Did the judge make the right decision, or would you have ruled differently? Share your opinion in the comments, and if you enjoy real courtroom breakdowns with legal insight and dramatic moments, don't forget to like, subscribe, and turn on notifications so you never miss the next case.